Hello, my name is Matthew Galluzzo, and I'm a criminal defense attorney at the law firm of Galluzzo and Arnone LLP here in New York City. Well, now that you've determined that you are eligible for expungement of your criminal record here in New York State, the next question is, what is the process like and what is it going to entail? Now, this is not going to be an automatic or routine administrative process. This is not like going down to the DMV and getting your driver's license renewed or updating your registration on your vehicle. Nor is this an application that's going to be granted automatically to each and every person who might be eligible. This is more akin to an appeal, because ultimately what you're doing with this process is you are asking a judge to exercise his discretion and give you something that he doesn't have to give you, which is to seal your criminal record and to expunge and wipe clean your criminal background. And he's only going to do that for people that he thinks deserves it. And so you're going back to the same judge that you were initially sentenced to, or sentenced by, on your criminal case, and making an application to him or her. And so what you're going to have to do is demonstrate that you have been rehabilitated and that you now need this expungement. Maybe you've suffered some hardships, or maybe you have some compelling reason why the benefit to wiping your record clean outweighs society's benefit in knowing that you have a criminal record. So the law is quite specific about what sort of documents have to be submitted to the judge in writing. They're going to have to be sworn statements from you, which an attorney can help you write. There's also going to have to be a submission, probably needs to be written by an attorney, explaining why you specifically deserve sealing and why you're a good candidate for it. You're also going to be able to submit character letters or other supporting documents attesting to your reintegration to society, or perhaps the hardships you've suffered, or your rehabilitation, or your remorse, or maybe your family situation. Okay, so there's really no set limit to what sort of documents you can submit in support of this application. Now, interestingly, this isn't a one-sided application, because the prosecutor that convicted you is going to be permitted, in fact expected, to respond to these applications for expungement. Now, in many cases, when people are particularly deserving of expungement, you may see prosecutors consent to the process, and a good advocate may be able to reach out to the district attorney's office and get them to agree. Obviously, an expungement application before a judge would be a lot easier and a lot better chances for success if both the prosecutor and the attorney for the applicant are on the same page, if they both agree that the applicant deserves it. But the district attorney might oppose sealing. They may read your submission and say, we don't believe that you've really rehabilitated. We don't believe you really need this sealing. We think society needs to know that you've been convicted of this crime, even today, even 10 or 12 or 15 years later, because it's such an important crime, because it's such a dangerous crime, and because employers deserve to know this thing about you and your background. And so you may see district attorneys writing responses opposing these applications, much as they would in an appeal. Now, after the judge receives these applications, this response from the prosecutor, the judge is going to be permitted to hold a hearing where testimony could be taken from witnesses, character references, etc., maybe about the underlying crime, maybe about the rehabilitation that's occurred since the conviction, perhaps the circumstances that necessitate the expungement. So this could be a very long and involved process. And there's not any sort of deadline here that the judges are going to be required to adhere to. It's not like these things get submitted and then the judge is required to decide it within 30 days. That is not going to be the case. A judge is going to be deciding these things whenever they get around to it in the course of their business. So if you're expecting a quick and easy result, that is just not going to be the case in this sealing application. That being said, it is going to be worth it for those people who are able to convince judges to expunge their criminal records. Just imagine, finally, after all these years, going into a job application and knowing that if you get that job, the background check is not going to ruin your chances of keeping it. They're not going to find anything on that background check, because your record is going to be expunged and sealed, and thus only available to law enforcement, or in the event that you decide to purchase a firearm. But for all the purposes, for most every purposes, once you have expungement, your background check will come up clean. And imagine how much easier that's going to be for you to finally get the job that you deserve, to finally take care of your family, to finally get that second chance that you've earned. Expungement is going to be hugely valuable to people with criminal records. And just because the process is not going to be easy, doesn't mean you shouldn't give it a try. But we highly recommend that you use the assistance of an attorney in this process. We think a process without an attorney is almost doomed to fail, because this process is going to be long and involved, and you need an experienced advocate, somebody who believes in this process to help you. And we, the attorneys at Galluzzo and Arnone, are the perfect people for you to consider hiring for this job. Give us a call at 212-323-7409 to discuss with us whether or not we can help you. Thank you.